Can you be charged with a DUI while you're parked in your vehicle? Here in Maryland, the answer is yes. But if you go into court and plead guilty on those charges, you might be overlooking a very strong defense. My name is Max Frizalone, and in this video, I am going to talk about Maryland's shelter rule. It's a discussion or rule born from the Atkinson case, a case in the then Maryland Court of Appeals, now Maryland Supreme Court, discussing a Mr. Boyce Atkinson and his DUI charge. See, Mr. Atkinson was parked on the side of the road sleeping in his car. Nobody saw him drive, and he never admitted to driving. And the question before the court was, can you find somebody guilty of a DUI without anybody seeing them driving and without them having driven or admitted to driving? These were the factors the court hashed out that we should consider in these types of situations. And by the way, the court said no, Mr. Atkinson was not in actual physical control of his vehicle. Let's jump right in. 1. Whether or not the vehicle's engine was running and whether the ignition is on. 2. Whether the vehicle is in park or in drive. 3. In what position is the person found in the vehicle? 4. Is the person awake or asleep? 5. Where is the ignition key, although probably less important in push-to-start cars? 6. Whether the vehicle's headlights are on. And 7. Whether the vehicle is on the roadway or legally parked. See, Mr. Atkinson was on the shoulder, and many of my clients are on the shoulder or parked in parking spots and still get charged with DUIs. If you're parked in a parking spot, asleep in the driver's seat, and your car is off and your headlights are off, then there's a very good argument you weren't in actual physical control of your vehicle. And absent some other evidence of your driving, or a statement by you to the contrary, it would be very hard to establish to any fact finder or jury that you were in actual physical control of your vehicle. However, and there is always a caveat, people leave their cars on for reasons other than driving. For example, the opinion discusses when a car might be left on for heat. So if it's the dead of winter and your car is on, then perhaps you're just sleeping when off in the heat. The Atkinson case had a dueling, conflicting interest here. On one hand, we do not want to encourage people to drive drunk. On the other hand, we do want to encourage people to pull over if they feel too impaired and not have the fear that if they don't continue and get all the way home, they're going to somehow get stopped for a DUI. So, this is a very case-specific and fact-specific type of defense. You need to talk with your criminal defense attorney about whether or not the shelter rule applies in your case. Because, for example, if you're parked at a red light in a lane of travel, you might not be afforded the same defenses as Mr. Atkinson or anybody else who's legally parked. If you've got a case in Maryland and you want to talk a little bit more about it with our attorneys, both myself and Mr. Woods would be happy to chat with you on any of our phone lines or have an attorney-client privilege meeting at one of our offices. Good luck.